Are you a software developer, a tech genius, or do you own a tech startup? Well, you don't want to miss today's Podisode because we're going to be discussing everything you should know about protecting software. Welcome to the Everything Intellectual Property Law Podcast. I'm your host, Ibatunase Radiola Shobambi. I'm a lawyer, content creator, an intellectual property and technology enthusiast, and I would also like to consider myself a creative at heart. I found a way to combine my interests to create and produce the foremost intellectual property and technology law podcast in Nigeria. The EIP Law Podcast is dedicated to providing its listeners with industry knowledge on a variety of intellectual property and technology-related issues. So if you don't want to miss out on more episodes like this, make sure you visit our website at Everything IP Law or follow us on Instagram and Twitter at Everything IP Law. Welcome to today's Podisode. Like I said earlier, today's Podisode will be addressing the various ways software can be protected and why such protection is important. Essentially, we're going to be looking at the contractual and intellectual property protection of software. So software is basically a body of programs, data and information used to convey instructions to a computer system, and I am very certain that most of us use some sort of software in our daily activities, whether it's using the Uber app on your smartphone to serve your transportation needs or making financial transactions through online banking platforms, or as simple as using your smartphone to send a message to a loved one far away. It's evident that software programs are essential in today's technology-driven world, and it's unimaginable to consider living without some of these softwares. In fact, in some jurisdictions, citizens have the legal right to access fast and reliable internet connection. So it's conceivable that in the nearest future, access to certain software or applications will be considered legal rights of every human. I said all that so we understand why it's important that software creators or developers are able to fully benefit from their work. And it is particularly important for the society to encourage such protection, as it is a driving force of innovation in the global economy. Having said all that, I'm going to approach this topic from two different spectrums. One is the contractual protection and the other is the intellectual property aspect. So I'll start off with the contractual protection aspect of software. So one of the ways a software can be contractually protected is through software licensing agreements. If this is your first time hearing about software licensing agreements, don't worry, I'll explain. A software license is a contract between a software developer and the consumers or end users. It provides the end user the legal right to use or distribute the software created by the developer. It is created to protect the intellectual property of your software, and it limits the ways in which the end users can utilize it. Software licensing is an integral part of your software innovation because it protects software programs from copyright infringements. A very good example of this is the Microsoft Office suite, consisting of popular programs such as Microsoft Word, Microsoft Excel, Microsoft PowerPoint. I'm sure we all know what Microsoft Office is used for. It is used by over 1 billion people worldwide, making it one of the most utilized softwares globally. So it's very likely that you must have come across the Microsoft license agreement. I know most people don't read those lengthy license terms that usually pop up on our screens, but if you read the Microsoft license terms, you'll see that it essentially defines the legal conditions under which the end user can use the software. There are different types of software licenses, but the distinguishing factor of the license is the term in which the end user may utilize, redistribute, or further develop the software. Typically, software licensing agreements can be grouped into 3 categories. We have proprietary, free, and open source. Some of these licenses provide that a particular software be used freely without restriction, while others may sell the copyrighted software for a fee. Despite the many software licensing agreements, it's important that a good software licensing agreement contains the limitations of liability, warranties, disclaimers, protections, and fair use of the software. Another contractual measure that may be adopted by a software developer is signing a non-disclosure agreement when dealing with third parties or sharing software codes with an external party. Basically, a non-disclosure agreement is a preventive measure to ensure that the public, competitors, and other third parties do not have access to your software without your permission. Now, moving on to the protection of software under intellectual property. Generally, software can be protected under IP by patents, trademarks, copyright, and trade secrets. So I'll start off with copyright protection. In Nigeria, software codes are protected by copyright law. According to Section 51 of the Copyright Act, computer programs, which include software codes, are registrable under the Copyright Act. In most jurisdictions outside Nigeria, software programs can be registered under copyright. But specifically in Nigeria, you can register your source codes or softwares with the Nigerian Copyright Commission by submitting a registration form, and the process is now digitalized, so one can simply register online through the Nigerian Copyright e-registration system. It's important to note that registration is not a mandatory precondition for protection under copyright law, so you don't have to register before you can exercise ownership of the software. Now, moving on to patents. Patents generally reward invention, and in this instance, patent protects the software invention, including the methods and processes. According to the Patent and Design Act of Nigeria, software is eligible for patent protection provided that the software is new, it involves an inventive step that is not obvious to the people knowledgeable in the field, and is capable of industrial application. Then the software can be patented under Nigerian law. However, for trademark registration, softwares cannot be trademarked because trademarks are distinctive marks used to identify the source of a particular product from the others. Although the software cannot be registered as a trademark in this sense protects the brand name, the logo, or the slogan under which the software is sold. And lastly, we have trade secrets protection, which is not a statutorily recognized right in Nigeria, but it is recognized and enforceable under common law. Essentially, trade secrets protect technical know-hows, including other confidential information that gives the owner a competitive advantage in the market. Now that I've listed both the contractual and IP measures for the protection of software, here are some of the benefits of protecting software. Primarily, protection provides the owner of the software or the software developer with the exclusive right to all aspects of the software program. It further prevents the unlawful imitation or copy of the software. And most importantly, the owner of the software can exercise economic rights by earning revenue from the commercial use of the software. To sum up all that has been said so far, if you're a software developer or technology company providing software solutions, then you should consider the intellectual property and contractual measures I have provided in today's Podisode. We've come to the end of today's Podisode. Thank you for listening. If you enjoyed today's Podisode and you want to join the conversation, make sure you subscribe to our podcast on iTunes, YouTube, and Google Podcast. For more updates, please visit our website at everythingiplaw.com, or you can follow us on Instagram and Twitter at everythingiplaw. Till next time, bye.